Okay, let's jump right into this explainer and unlock the highly structured and sometimes terrifying world of contract damages. Look, if you've ever stared at a contracts exam prompt and just felt a wave of absolute panic about how to calculate exactly who owes what, you are definitely in the right place. Today, we're moving way beyond the basic theories of breach. We're diving into the exact black-letter laws, the core definitions, and the ultimate framework you need to absolutely master remedies.
Here's our roadmap for today. We'll start with a quick intro to contract damages, unpack the MPEACADLLC mnemonic, cover standard damage limitations, dive into special damage exceptions, tackle liquidated damages and penalties, and finally wrap up with exactly how to ace that contracts essay. Let's get to it.
Section 1. Intro to Contract Damages, the Foundation of Expectation. We're starting strong by establishing the overarching absolute golden rule of contract remedies. They are compensatory, not punitive. The fundamental purpose here is strictly to focus on the economic reality of the exchange. Contract law, believe it or not, does not exist to punish the breaching party. It's just there to fix a financial imbalance.
Notice how this excerpt from Section 12.01 explicitly outlines the core of our legal framework. Courts are basically trying to satisfy one of three remedial interests: expectation, reliance, or restitution. Now, while reliance damages help recoup expenses, and restitution prevents unjust enrichment, there is an undisputed king of the hill here that you absolutely must always address first.
And that brings us to expectation damages. This is the standard default remedy you have to look for right out of the gate. The black-letter law demands that we award an amount sufficient to give the aggrieved party the benefit of their bargain, putting them in as good a financial position as if full performance had actually happened. Now, if you can't prove a measurable financial loss, your recovery is strictly limited to nominal damages. Like a token $1 award, just to officially declare, yep, there was a technical breach.
Moving right along to Section 2, the MPEACADLLC mnemonic, your secret weapon. Contract law applies strict limiting principles to any claim for damages. Why? To protect parties from unbounded, infinite liability. But remembering all of them under the pressure of a ticking clock can be brutal, while this acronym is going to be a total lifesaver.
This massive 10-letter mnemonic perfectly chunks every limitation and exception you need to know. Memorize this exact phrase. Many plaintiffs experience anguish concerning alternate deals losing liquidated cash. That single sentence gives you MPEACADLLC. Seriously, write this at the very top of your scratch paper the absolute second your exam begins. It's a game changer.
All right, Section 3, Standard Damage Limitations, the MPEAC rules. We're going to deconstruct this mnemonic by first looking at the general limitations that apply to standard damage calculations. This first half, the MPEAC, represents the roadblocks that courts use to stop plaintiffs from just asking for way too much money. These first four letters block plaintiffs from claiming unmitigated losses, coercive punishments, emotional payouts, or legal fees. Let's break it down. M is for mitigation. The injured party has a strict duty to take reasonable steps to minimize their losses rather than just sitting back and letting damages pile up. Next, P is punitive exclusion. Remember, no punitive damages unless the breach is also an independent intentional tort. E is emotional distress. Contract law honestly doesn't care about your broken heart, only your broken wallet, so anguish isn't compensated. And A is the American rule, meaning everyone pays their own attorney's fees unless a specific statute or the contract explicitly says otherwise.
And that brings us to the C in our mnemonic, construction damages. Think about a scale balancing broken infrastructure against a single coin. When a builder breaches, courts have to choose between the cost of performance or the diminution in value. The classic example here, Jacob & Youngs v. Kent. A contractor built a $77,000 mansion but accidentally used Coho's pipe instead of the identical quality Redding pipe that the contract specifically asked for. Tearing down the walls to replace it? Enormously expensive. So the court said the breach was just technical and trivial. Instead of forcing that exorbitant replacement cost, they awarded the diminution in value. And since the pipes were identical in quality, the damages were totally nominal. Moving to Section 4, Special Damage Exceptions, the ADLLC rules. Let's see how this builds into the back half of our acronym. These rules focus on special exceptions and precise calculations that love to pop up as traps on essay questions. Now, while A and D handle the nuances of employment mitigation, meaning a wrongfully terminated employee absolutely must look for alternative employment, but they do not have to accept work of a different or inferior kind, the C at the very end stands for the cash or certainty requirement. This is a big one. It mandates that you can never award speculative damages. Your lost profits or financial harms must be proven with reasonable certainty to actually be recoverable in cash.
This brings us to the first L, the lost volume seller. This concept is heavily featured in the famous sucker play of Nuri v. Retail Marine Corporation. Imagine a retail dealer selling a standard-priced boat. The buyer breaches. The dealer then turns around and sells that exact same boat to someone else for the exact same price. A standard market minus contract calculation would say the dealer lost $0, right? But wait, that's a trap. As a lost volume seller, that second sale is treated as additional volume, not a substitute. Because of the breach, the dealer made one sale instead of two. Therefore, the court awards the full lost profit from that initial breached contract.
Section 5. Liquidated damages and penalties, the final L. Let's tackle this second L, which requires you to determine if a pre-written contract clause is a valid forecast of damages or an illegal punishment. This is the whole doctrine of liquidated damages.
Here's exactly how you spot this on an exam. Parties can pre-agree to a specific dollar amount for a breach, but if the set amount is grossly disproportionate to any realistic loss, it acts as a trap, basically an inter rerum clause designed to terrorize a party into performing. If it's deemed a penalty, the court will strike it down entirely and boom, you default right back to standard expectation damages.
This quote from Judge Posner in Lake River Corp v. Carborundum Co. perfectly cements the economic reality that invariant, blind damage formulas overcompensate plaintiffs and flat-out violate public policy. In that specific case, a single formula applied blindly to both minor and major breaches, and it refused to subtract expenses saved when performance actually stopped. The court flat-out rejected it. Contract law blocks private parties from implementing coercive economic punishments.
Okay, Section 6, Acing the Contracts Essay, the law student's blueprint. We've covered the black letter law, the rules and the definitions. But how do we successfully shift from knowing all these rules to actually using them to ace a contracts essay?
So, how do you write the perfect contract remedies essay? The answer lies in adhering to a strict, sequential analytical flow. Listen closely because this is the master key to your exam. You can't just throw all your knowledge onto the page in a random order and hope for the best. You have to show the grader exactly why a specific remedy applies by systematically ruling out the others in a logical sequence.
You must march through these steps in exact order. Step 1. Check for an express liquidated damages clause. If it's valid and not an illegal penalty, it is your exclusive remedy, and your analysis stops right there. Step 2. If there's no clause or it's struck down, apply the standard forward-looking expectation damages. Step 3. Apply the MPEACADLLC checklist to see if those expectation damages need to be reduced because the plaintiff failed to mitigate or maybe because the damages are just too speculative.
But what if expectation damages are inadequate or literally impossible to calculate? That's when you pivot to your alternative, restitution in quantum merit, meaning as much as he has deserved. This ignores the contract price and awards the reasonable value of the performance rendered. However, you've got to watch out for the liquidated debt exception. As seen in cases like Oliver versus Campbell, if you have fully performed your side of the contract and the only thing left for the breaching party to pay a specific fixed sum of money, a liquidated debt, you cannot claim restitution. You are limited to recovering the contract price. No exceptions.
Finally, as you write, never forget the overarching chronological progression of contract law, which we can playfully call the rule of no backsies. Don't let a complex remedies issue confuse your already completed formation analysis. Once a contract is formed, a later dispute about damages doesn't mean there was never a contract to begin with. Keep your sections clean, distinct, and moving forward.
You now have the ultimate framework. Keep this blueprint close. Trust the sequential analysis of expectation, limitations, and restitution. So ask yourself this, when you sit down for that exam, are you going to let the complex facts distract you? Or will you use MPEACADLLC to cut straight to the core of the economic loss? Keep this explainer handy, trust the process, and go dominate your next contracts exam.